In Katlehong, where Pastor Paseka Motsoeneng, popularly known as Mboro, and 4 other people were arrested in connection with the violent scenes that played out at the Matsediso primary school. The incident is allegedly linked to a family dispute involving the custody of Mboro's grandchildren. It is said that the mother of the children passed away earlier this year, leading to a dispute between the paternal and maternal sides of the family. Let's look now at what the law says in situations like this. I'm joined by Phiwokuhle Mathenjwa, who is the managing director at Mathenjwa Attorneys. A very good afternoon to you, Phiwo. Thanks very much for your time. Assuming that indeed what the little that we know about this particular incident, the mother passed on, and now there's this big fight between the maternal versus the paternal grandparents, without, of course, knowing the actual details or specifics. It becomes a tricky one. But what can you say about this situation, given the little that we all know?
Good afternoon to you and your viewers. First of all, I would like to say this is heartbreaking, to say the least. And in respect of the law, we are going to look at least at 5 different pieces of law, which is your Schools Act in respect of safety, your Criminal Procedure Act in respect of the weapons that were used, and what remedy or what can the teachers do in respect of what had transpired. Then we look at the administration of the Deceased Estates Act, as we are aware that the mother then passed away. And then Firearm Controls Act, we see that there's a firearm that is held there by one of them. And then lastly, and most importantly, we look at the Children's Act. Now, when there is a dispute between parents or parties involved in respect of what we call, as layperson would say, custody, but in the legal terms, we call it primary residence. That is when we want to ascertain who is going to reside with the children. We call it primary residence. And then the other parent or an interested party then exercises what we call contact and care. You will see that another parent or interested party will have contact with the minor children over the weekend, over school holidays, and so on and so forth. And then what we ordinarily also call guardianship. The most exciting news that we had was that now we can also even approach the children's court if you so feel that you've got a right and you want to apply to be awarded guardianship over the children.
So presumably a Pastor Mboro would have, although I'm not sure if we can assume that to be a fact, that you would have been aware of, what the provisions of the Children's Act is in terms of custody and primary residence. If, for argument's sake, these children were supposed to be staying with their maternal grandparents, that's what ought to have been respected.
Of course. But you see, when we've got little information, now
yes.
Giving legal advice becomes a problem. I want us to create at least 1 or 2 scenarios herein. The mother, who is now deceased, was staying with the children in terms of Section 20 because she's got full parental rights and responsibilities. She was the children were in her primary residence. Now, the father would, under these circumstances, if they did have a parental rights and responsibilities agreement in place, then would have what we would call contact and care, right? Now, when the mother passes on, who assumes it automatically? Now, that is where I was very much concerned. We don't have the automatic part of it. Because now the father herein, if there was no parental rights agreement between them in respect of how he was exercising his responsibilities and rights in respect of the minor children, who then gives him an automatic right? Because the definition in terms of Section 21 where we say, what are your rights and responsibilities as an unmarried father? Because they differ when you are a married father and when you are not a married father. The Children's Act is there to regulate such things and explains to us how we go about it. Now, under this situation, we would assume that the maternal grandparents assumed basically automatically the primary residence in respect of these children. Now, if they wanted to do things accordingly, the first step is, one, you approach either the court by bringing an application to have contact and care. That is when the court then, after hearing the application, might say, in fact, no, the father must have primary residence, and then the maternal family will have contact and care. In other circumstances, they might say, in fact, it is so correct that the maternal grandparents be awarded guardianship, and then the father and the paternal grandparents will have what we call contact and care. So step one, you approach the court and bring your formal and necessary application seeking the prayer that you so want. Two, you involve social workers. Simple thing, easy, less expensive, or you go to your legal aid officers. They've got a mandate to deal with all these issues where children are involved if you do not have funds to pay for your private legal representation. Now, when you go to your social workers, they will compile a report that they will take to court and say, no, in fact, this is how this should happen. Remember, children matters are urgent applications in their nature. They never take. So now what Pastor Mporo is seen to have been doing is what we as the legal fraternity always discourage, taking the law into your own hands. Why did you not go to social workers for their intervention and to seek what they can do? Remember, even schools, when children are involved, the Children's Act is applicable because the school was also going to assist Pastor Mporo in assisting his son to get what he so wants, be it primary residence or contact and care of the children.
In other words, you follow due process, no matter how aggrieved you might be, or no matter how right you think you are. But you don't walk into a school carrying pangas and firearms like they did, which then brings us to the Firearm Controls Act, which in this instance would say what?
Let's look at first, to whom did that firearm belong to? Number two, is it a firearm in terms of the definition of the Firearms Control Act? We look at possession of prohibited firearms, because what firearm is that? Because we've got firearms that are prohibited to be possessed by certain civilians and so on and so forth. We also look, I want us to take into account the seriousness of this matter, the Criminal Procedure Act. You see, assault, GBH, has got its own elements that must be proved at court. And what is important is threat must be imminent. It does not mean that you must actually assault this person. If I believe, because as you see him swinging that panga around, threatening people like that, and we take it an extra step to say the National Prosecuting Authority can even say, in fact, no, it's not even assault with intent to cause grievous bodily harm. In fact, it is attempted murder because a weapon on its own is also taken into account.
Yes, I mean, you could see those teachers in front of him threatening them, and of course outside also as he was trying to like wave it at the other people. In the interest of time, let's then go to the other three categories. You were talking about the administration of the deceased's estate. Of like, how relevant is that part of the law in this instance? Obviously, again, with the little that we know so far.
Why are they so interested all of a sudden to claim these minor children? Now, that is in the mind of each and every person, why are they so eager to take them and they be in their primary residence? Let's take, for example, that the mother of these minor children was not married. And for a straight out figure, let's say the estate is worth 1 million rand. Who is going to inherit this estate? It is the minor children. Now it means each minor children is going to get estimation at about 500,000 each, right? Now who is going to have access to that money in the day-to-day expenditures that these minor children are going to have, paying for school fees and everything and so on and so forth? So it now begs the question, are they not being interested in the administration of the estate of the deceased mother, because the only beneficiaries would be the minor children under the said circumstances?
And quick last points on the fact that there were weapons other than firearms that were involved, and all of this happened in a school setting.
That's why I said this is heartbreaking, to say the least. Remember, you see hearing the minor children cry in such a manner when they grabbed them, taking them out. We do not know even if that firearm is already cocked and ready to fire. What dangers were these minor children exposed to? What about the other children in the school when such instances happen? And whenever I comment on such issues, I always say, you take your rights. If you feel that you've got such an absolute right, you take into account your responsibilities. And above all, it is not about you. It is not about the mother of the children or the father of the children or anyone else, but it is about the minor children, the trauma that they are left with. My child attending that school, the trauma that they are left with when they need to attend school the following day. So whenever we decide to take the law into our own hands, or we want to take action over us being aggrieved by the legal system, we must keep it in mind and in our hearts that it is not only going to affect us, but the child that is so involved.
Phiwokuhle, thank you very much for your time and insights. Really, really appreciated it.